Hi, welcome back to the Retail Lawyer. I wanted to take an opportunity today to talk to you a little bit about commercial rent relief. Now, if you do follow the Retail Lawyer on LinkedIn, you'll know that in the middle of March, I had posted a 2-page summary for my clients in my network, giving some thought to factors and considerations when we first started thinking about the pandemic and what it could potentially mean in the rent obligations. More than a month has passed now, and as this moves forward, I'm sure many of you are feeling the crunch. I know my clients are, whether you're on the landlord side of this equation or if you're on the tenant side. And I'm specifically speaking to commercial situations today. I'm not talking about residential situations, residential leases at all. Okay, so keep that in mind while we talk. And again, this is just general information. If you want legal advice, you really need to contact your attorney, and they'll walk you through your specific lease documents, conversations to have with your landlord, potentially have those conversations for you, document them, and then you can move on and hopefully get through this difficult time. So what I did, and as usual, just as a reminder, I have my little 1-page thought sheet, little summary, kind of talking about some of these points and listing them out for you basically. And if you want to get a copy of that, you can find me at the Retail Lawyer on LinkedIn, or you can find me at the Retail Lawyer on Facebook. And you can message me and I'll send it to you, and we can go from there, okay? So where we need to start is, you may or may not have had conversations with your landlord regarding your rent situation yet, or your tenants. More than likely, for your landlord, you have reached out if you haven't received that rent payment. And tenants need to proactively deal with the situation because there is a contract in place and the obligations may stand, depends on what's in that lease document. So, tenants are thinking about, is my business open? If it is open, to what extent did I have to pivot? So many of the restaurants now have pivoted in such a way that they have curbside only, they don't have dine-in, so obviously their income has gone down. Essential businesses are open, so they seem to be doing okay. So I doubt that any kind of grocery store or pharmacy is really going to get any rent relief at this time. But restaurants, apparel retailers, small retailers, specialty retailers, people of that mindset are most likely going to need some help, as well as offices. I mean, some offices can continue working remotely, but not all. And so those are kind of types of businesses that really need to think about, what can I do? What is my financial circumstance today? What disaster relief is available to me? Whether it's loans through the SBA, whether it's loans through other resources, whether it's insurance coverage, which we'll also talk about in this segment. Are your customers paying you? What can you count on? And going through your contracts, which I'm going to do another segment on, talking about looking at your contracts to see if there's any kind of flexibility built in or exit provisions that you could utilize as part of your conversation with your landlord. But that's going to be a different segment, so you'll want to stay tuned and watch that one as well. But here, these are the things as a tenant that you're thinking about. I'm in this circumstance now. I have a business. I have employees to pay potentially. Can I get the SBA funding through the Payroll Protection Program, PPP? Did I get an EIDL emergency impact disaster loan, which that advance? Is it enough to cover the basis of what I need to do? And is there enough left over after I pay payroll to actually pay my rent? What can I or can't I do? What's available to me to talk to my landlord about so that we can work together to find an answer here? Because contractually, you're more than likely in a place where you still have to pay the rent. Because force majeure provisions, which your lease may or may not have, but even if it does, many times it very expressly excludes the ability to prevent monetary payments. You still have to pay your money even if the other party's not performing. Not fair necessarily, but it's still within the contract. So think about that. If you're on the landlord side, your big question is, are my tenants paying me? And if so, or if not, can I meet the requirements of my lender? There's been within the stimulus programs and the CARES Act, you've heard that phrasing. So there's been provisions in there protecting borrowers on the residential end, but not on the commercial side. So even if you are a landlord, and I said I wouldn't talk about residential, but I just want to make this point. So even if you're the landlord of a small building or a large building, and you have all residential tenants, your loan is still a commercial loan. So There's a lot of commercial real estate implications going on that haven't been addressed yet by a stimulus plan. I'm hoping that the next one will. I'm sure we all are hoping that, because then that can trickle down to some sort of relief to tenants. But in the meantime, the commercial landlords find them in a very tough spot. They are stuck between tenants who say they can't pay and maybe can't pay, and lenders who say, I don't care, you still have this obligation, you must pay me. And I'm going to put you in default, and I'm going to go after the collateral. And it's a very dangerous and precarious situation for the landlords to be stuck in right now. So you have to think about it from both sides of the equation. And that's why I said it back with my 2-page summary, and I'll say it again. If there's a way to negotiate a business settlement of the situation, that is the best way for all parties to go, because you're going to have an ongoing relationship. Litigation right now in many states, whether it's commercial or residential, evictions are on hold. So as a landlord, you can send the default notice, you can start the process, you can kind of reserve all your rights and make sure that there's no thought that there's a waiver happening here, but you can't actually act upon it in court yet. So that could be a leverage point for you to go ahead and send those notices and say, look, I'm still following up on this. But that doesn't necessarily mean you're going to get the relief you need. So what do you really need, landlord, for your lender? What do you need to prevent default? So there's a lot of different ways to look at this. And so the things that you can think about are, can we use security deposits? Is there a way to negotiate with the landlord's lender for interest-only payments, so it's a lower amount on a short term? At the bottom of my little summary, I've got some lease provisions to kind of look at to help you figure out what your rights and obligations are and where you may or may not have flexibility. So how do you work this out, right? So force majeure, let's see if you have that provision in your lease to begin with. And then let's see if it's narrowly written or broadly written. As I mentioned, it most likely has an exclusion about monetary obligations, that those still need to be met. It may not, and if it doesn't, that helps you, tenant, right? If it does have that language, that helps the landlord's argument. It may have a catch-all, a very broad language talking about foreseeability and control. If it's out of the control of the party, the reasonable control of the party, then it still falls within the force majeure. Or it could be very narrowly listed and talk about declarations of war, labor strikes, civil riots, things of that ilk. And if it's a specific list without any kind of broader language attached to it, it's going to be a harder argument for the tenant party. So keep that in mind, okay? But we all know that there's something happening here, and how this language will be interpreted is questionable right now. In the past, force majeure provisions have been drafted and construed, I should say construed, not drafted, construed very narrowly by the courts. That doesn't mean that that's what's going to happen tomorrow. Courts can change their minds. They're supposed to work on this basis called stare decisis, which is basically precedent. So as it's been confirmed, as courts have decided in the past, you must follow that. But that doesn't mean that language can't be built upon or extrapolated from. So there is a potential for these to be read more broadly. So landlord, don't think this is a slam dunk for you. I think this is a time where we all have to be reasonable. And as business people, which we all, on both sides of this equation, we are, our best approach, I think, is to get back to business. And what are we going to do to put us all in the right circumstance to get back to business? So again, we're going to look at force majeure. We're going to look at, for retailers, specialty retailers, is there an operating covenant? Is the language in there that specifically says you have to be open and operating for a certain period of time? Many times when there's an operating covenant, there's a sister clause called a co-tenancy clause. And that says, well, I only have to be open and operating if so many of the other people are open and operating. And that really falls more into enclosed mall situations, strip centers, things like that. If you have a standalone lease, that's not going to be the same thing. And that's part of the question too. If the tenant is in a triple net situation in a standalone property, I don't think they have as strong of an argument regarding force majeure, so to speak, than somebody who's in an enclosed mall where the landlord has locked all the doors and I can't get in, right? If it's in a strip center, then, is there a way that you can still operate your business because you're doing curbside pickup, because you're only allowing 1 or 2 people in the store at a time? It changes the conversation based on what you can and can't do within your space, based on your, another provision, permitted use. What does the permitted use provision in your lease talk about? What does it allow you to do and not to do? Is there some negotiation there? Maybe there's actually language in there that doesn't allow you, if you're in a strip center or a street location, to have signage outside or a stand outside your door. Well, maybe this is the time to say, hey, landlord, you want me to pay you any rent? You need to allow me to operate from the sidewalk. And if there's going to be a city violation, I'll deal with it, but you need to let me do it so I'm not in default of the lease. Maybe that's something to talk about. Is there even a concept of landlord default? You would be surprised at how many commercial leases there are, whether it's retail, restaurant, or office space, that doesn't even address the concept of a landlord default. That good luck to you proving it. You have to really show and work on building the case of the landlord didn't meet its obligations, as opposed to there being, as there is in every lease, a provision that says tenant defaults, and it lists out every little thing you could possibly do, especially non-payment of rent. That would be a default. So those are things to think about. The security deposit, how large is it? Can it be used for rent on the interim basis that you'll then repay over time? CAM, is there relief on the common operating charges, the common maintenance charges, operating expenses? They're all called different things. Common area maintenance is CAM. So anyway, so they're called different things. Utilities, right? Additional rent. So now people aren't using the space. Is it a flat rate, or are you metered? Are you sub-metered? If it's a flat rate, maybe there's something to negotiate there. Is there parking fees? If there's parking fees built in as additional rent, can you take that out right now because nobody's parking? Where can you find relief? Those are the things that you want to look at. What are the remedies? And I mentioned the remedies because tenant, you need to understand the implications if you don't pay your rent. Can the landlord accelerate the term of the lease, meaning that you owe all the rent for the full term of the lease now? Can they charge you interest and penalties? Can they charge you for configuring the space for the next tenant, the broker's fees that they paid when you came in, as well as the broker's fees for the next tenant that they got to bring in? How much of that kind of stuff can they look back to you? Because tenant, you need to understand the full implication of what the costs could be. And then landlord, you need to remember that the commercial real estate market was struggling already, and in many sectors, not all, but in many sectors, and it's going to take a big hit now because people are going to be looking at work differently. So are retailers going to need as much space? Are they going to be losing their stores and focusing more on e-commerce? Restaurants focusing more on curbside. If they have to have larger spaces, are they willing to pay the same amount per square foot, right? So you got to think about all of those things. Then on top of that, you have to think about the office space. Now all of a sudden everybody's been teleworking and telecommuting, whichever phrase you like. The reality is a lot of tenants, maybe you're going to say, we're talking office space now, we're going to say, I can have people telecommute, I can have people stagger, I can have people come into the office 1 day a week as opposed to 5 days a week, and we hot desk it, right? And all of a sudden, I don't need all this space. So landlords, you need to start reading the tea leaves and realize that you need to work with your tenants. And tenants, so it's a symbiotic relationship, as it should be. So look at both sides, look at your strengths, look at your weaknesses, and then figure out what you can do. And I raise all of this because there's so many factors and things to consider. And while you may think you have a strong position, you may not. When you litigate, you don't know what you're going to get. It depends on the judge. If there's a jury situation, who's on the jury? It's going to depend on the mood. It's going to depend on the experiences of the law clerks. How good is your attorney? How good is the other attorney? How good are the motion papers? There's so many X factors, and the cost of litigation in terms of just pure money to the lawyers, then time, there is a severe cost, and the distraction. So I highly recommend that you take a moment and have an honest assessment of your lease documents and think about what you can and can't do. Maybe it's a matter of the landlord, you agree, tenant, to waive co-tenancy provisions. The landlord agrees to modify operating covenants. You get into an interest-only payment for a lower rent that covers the interest-only payment for the lender of the landlord. Or maybe it's a matter of there's a deferment. If the landlord's got deep enough pockets that they can absorb the cost for a little while, you get a short-term deferment, and then you come in on percentage rent. And maybe it's a higher percentage rent for a certain period of time to try to make up for some of this lost time. With any contract, the leverage position powers of the parties impact a lot of what the outcome is going to be. So if you're both mom and pops and you're on equal footing, okay. If one is a mega conglomerate and the other one is desperate for the tenant, it's going to be a different conversation. But be realistic, look at what your contracts tell you, but let common sense be your guide. And that is my advice as the retail lawyer. If you want the one-page summary, let me know. And I will be doing another segment, as I mentioned, specifically on force majeure, frustration, impossibility, and business interruption insurance. So thank you for your time and have a good day.